People against Andrew Stephen Ciak, 25T71744451.
Good afternoon, John. Ali on behalf of the people, PA 6528.
And may it please the Senate of Court, on Tucker Davis, P59, representing Mr. Andrew Ciak, who's on my right. Can you introduce yourself, please?
Andrew Stevens, I.
All right. Anything else?
Your Honor, I believe we completed our arguments in the last hearing and we were here today for your decision after you completed the transcript.
Right.
Last statement.
So defendant is charged with assault with intent to do great bodily harm less than murder by strangulation. There's also an assault or assault and battery wherein he is the defendant, as well as there's a co-defendant, his daughter, one Brianna Pett, and then he also has a domestic violence second offense notice. Officer Hughes of the Trenton Police Department testified.
This courtroom is about to swing in two completely different directions. One defendant walking away from a serious strangulation charge, another being bound over on alleged parental kidnapping with a $50,000 bond hanging over his head. We've got conflicting testimony, bruising evidence that may or may not matter, judges questioning credibility in real time, and tense custody disputes that explode into criminal court. One ruling hinges on whether choking actually meets the legal definition of strangulation, while another turns on whether a court order was flat-out ignored during Christmas break. Stick around, because today's docket is packed with dramatic reversals, legal razor-thin decisions, and moments that could change these families forever.
Arrived at the address at 39114 Fort Street, apartment 221, on the date in question, June 22nd of 25. He arrived sometime between 1 o'clock in the morning. When he arrived, the victim, Shelly Zajic, had a black eye on her left side. She was cleaning. She was upset. Defendant identified Mr. Ciak as being the perpetrator, saying he did it. There was a lot of testimony about how the three of them were together. When I say the three of them, Mr. Ciak, his daughter, Ms. Pett, and Ms. Zajic, that they'd been out. She got sunburned. She said she had too much to drink. They came back to the house, or the apartment, that is. He then, Mr. Ciak and or Ms. Pett took Ms. Zajic's car without her permission and left the defendant Petts, who's not here, she says that a warrant issue, left her dog at the house. She in turn called Mr. Ciak, but he wasn't answering. She got a hold of Ms. Pett. Ms. Pett came back, and there was an assault without question. The victim testified that there was hitting of her in the back and in the head, first by Pett and then Ciak. That Pett punched her in the head, that started choking her, had her hands around her neck. She said she did not lose consciousness, is what Officer Hughes testified to. And again, to me, this whole thing boils down to there's enough here for sure to establish that there was an assault. And I'm only focusing on Ciak now, but there was a lot of conflicting testimony. The officer said that her left eye was blackened, but her right eye was not. There was also evidence and testimony that this had happened on a multitude of occasions, and that her eye had been bruised from previous incidents involving Mr. Ciak, which certainly I'm not going to consider. There was also, I believe, evidence or testimony from her that the officer, that she had a blackened left eye, But the issue was whether or not it happened on the right side. And as far as I could tell from the officer, the only thing that he observed that was new, a new or fresh injury, because he talked about several times about having going out there, was a bloody nose, that she had the black eye from before. She testified too, she did not, there was no evidence she lost consciousness as a result of this choke. There is no evidence that she was unable to breathe because of this choke. To me, and you know, I'm going to tell you how I feel about it, and then you can take your appeal if you want. And I did look at this. Strangulation or suffocation means intentionally impeding normal breathing or circulation of the blood by applying pressure on the throat or neck or by blocking the nose or mouth of another. She said she was choked. That's what she said. The victim said she was choked. But to me, the evidence and testimony, even on a probable cause standard, doesn't rise to the level where I can find by a probable cause standard that there was suffocation or strangulation. I mean, she said she was choked, but there's no evidence whatsoever that her normal breathing or circulation of the blood was impeded because of the pressure applied to the throat or neck, and no evidence that he blocked her nose or mouth. I mean, it's a close call, but I also want to say here respectfully, I was not that impressed with the victim's testimony. She was not answering the questions. I mean, I sat and listened to this again on tape, just as I was here. And it's kind of like if the witness, and the instruction's clear. I mean, if the instruction is the witness trying to evade the questions or argue with the lawyers, or is the witness giving honest answers here? And it just seemed to me like she was jockeying around the whole time, giving answers to things that were not asked. I didn't find her to be a very credible witness. There wasn't enough there for me to find that there was assault with intent to do great bodily harm by strangulation or suffocation, and therefore I'm not going to bind over on that. That case is dismissed, so I'm dismissing that count, and I'm going to retain the case here. And I am going, well, now, can you remind me of something? Do you keep the case or does it go to our local counsel now?
You're on.
Okay, so I'm dismissing, count one is dismissed altogether. And counts 2 and 3 will remain here. I got to move this along. I'm setting a final pretrial and a jury trial right now. So we need to get a final pretrial, which I'm going to presume was going to be in a couple of weeks. I'd like to do it on the 20th if everybody's available in the afternoon.
20th?
Yes.
January 20th?
Yeah. And then the jury trial. Yeah, that's the final pretrial. Jury trial we have to have. When are we going to have a jury trial? Or bench trial, whatever you guys want, but I'm just saying, I'll set it for jury now. If you confer with your client.
Not here the 20th.
Oh, that's great. I'm not here the 20th.
What about the following week, the 27th?
Yeah, I can do the 27th. Yeah, at 1 p.m. And then we'll do a jury trial. We got to do it in February, though. You guys, what day did you say you were available that he wasn't?
February 6th.
Can you do February 6th, Ms. Tucker Davis?
February 6th is a good day.
February 6th at 8:30 for the jury trial. Okay, so January 27th at 1 p.m.
What's it being said, a jury or a bench?
Well, I mean, that's up to them. It's up to you guys, whatever you want. I mean, he has the right to a jury trial. So I will set it for January the 27th at 1 and February 6th at 8:30. Lisa, we can get away with waiting until the afternoon of the 27th to mail out the notices, right?
No, I'll have to do it ahead of time because that's only 10 days.
What do you think the chances are this is going to resolve? Any chance? You guys don't have to tell me. I could care less. I just want to know. Should I have her send out the jury notices? Is it?
As of right now? I I don't know.
Okay, look, we'll send out the jury notices. I hate to do that, but I don't have another date. So February 6th at 8:30, instructions due by February 2. But I need them by the noon on February the 2, and they're gonna have to be in the same form that I talked to you about, okay, Ms. Holloway?
Okay.
And I mean, yeah, that's it. I wish you all well.
Thank you.
Good luck. Thanks a lot. So we go down the hall, get your note. Thank you.
Here, huh?
Now, Timothy Wayne Shelton, 25B705118. Give me just once. All right.
Governor James Anderson, P3130 on behalf.
Oh, boy, you're one of the old timers like me, huh? Your name?
Timothy Shelton.
Your name? Are you on this, Ms. Holloway? No.
No,
Where's the prosecutor?
Not familiar.
Yeah. Do you have to, you don't have to stay here.
Judge, I have one matter that Aaron Fleischer wants to go on the record regarding bond. That was my understanding, Judge. He's still,
I was just saying, I wouldn't mind.
well, I apologize, Councilman, I'm not trying to step on your toes.
No,
I'm not changing my mind on the bond. If you feel like you have to do it and he's still out there, Lisa, bring him in. I don't have a problem, but I'm gonna need.
He
the
logged
file.
off.
Okay, then that, Judge, since he's got other issues to deal with, I don't have a problem in adjourning this matter. When can we, is it next week or?
Didn't we set up that already?
Yeah, we set it for a final pretrial next week and a competency.
I
Yeah.
want to make sure.
So, and that's gonna be in front of Judge Hessen. It goes to her, but we're gonna prepare the order for competency.
Okay, thank you so much.
Thank
Everyone
you.
have a good day.
Hey, you too. Thanks for your help.
No, thank you.
All right, counsel, your appearance.
Good afternoon, y'all. I'm asking answer on behalf of the people.
Can you spell your full name again for my recorder?
Of course, Nathaniela is spelled Nataniella, and my last name is Asmaro.
Okay. All right, thank you. Today's the date scheduled for a preliminary examination. The charge is parental kidnapping. It is alleged that the defendant, Mr. Shelton, did take or retain for more than 24 hours his child, one Sarah Pasalacqua, with the intent to detain or conceal her from her other parent or legal guardian. That's punishable by a year and a day. Any preliminary matters here?
No, Your Honor.
Any preliminary matters, Mr. Anderson?
Your Honor, I think the victim's name, the plaintiff, I think you mentioned Sarah Pasalacqua.
Yeah.
I think that is the mother of the child.
Well, she would be the victim, right? I mean, she's named as the victim for in place instead of the child, right?
That's correct.
Okay, so, all right. Any preliminary matters?
No, Your
None.
Any preliminary matters from the defense?
None, Your Honor.
Call your first witness.
Thank you. People call Miss Sarah Pasalacqua. I can't say the last name. Lacqua. And I can spell that. Sarah is Sarah. Last name Passalacqua.
Thank you. Ma'am, raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. Okay, have a seat. Now, I can tell right now you're soft-spoken. I need you to really keep your voice up for me, okay? You can proceed. And no mm-hms or uh-huhs. Nice and loud, like you're talking to people on the other side of the wall there.
Thank you, Your Honor.
Thank you.
And Miss Sarah Pasalacqua. Good afternoon. Is it all right if I call you Miss Sarah? Yes. Thank you. And now, Miss Sarah, do you know an individual by the name of Mr. Timothy Shelton? Pardon? How do you know that individual? I share a child. Okay. And is there any other relationship with this individual?
We've been together for over 6 years. We ended our relationship, and together, when our son was 6 months old.
Okay, and who's your son?
Noah Shelton,
How old is Noah today?
he's 14.
Okay. And are you familiar with the address of 2206 Dale Street?
Yes, that's my address.
Okay, is that in the city of Brownstown, County of Wayne?
Yes,
Okay, and I wanna draw your attention back to the date around Christmas time, December 23rd, 2025. Do you recall that time? Okay, did something happen that day that brings us into court?
Nice and loud for me.
December 24th, Timothy and I, agreed that our son would be returned to me, we lived at Christmas Eve.
Wait a minute, wait. Maybe you're talking loud and I just can't hear like I used to. You gotta go a lot louder, like you're talking on the other side of the wall. So Tim, the defendant, and you agreed that he would return your son to you on the 24th
Yeah.
of December.
Yeah.
Okay, now continue nice and loud.
And, I, around 10 something, I messaged my son's phone and said, when we'll be back. And then, Tim responded saying, this is Tim.
And Sarah, let me stop you there, go a little bit farther back. You stated that you guys had an agreement. Is there any sort of order or anything in place between you and Mr. Timothy and this child that you have?
Yes, he has, parenting time, he had parenting time, where he would pick him up Saturday mornings at 10 a.m. and return him by 8 on Sundays.
And was this an order?
Yes,
And do you recall if it was signed by a judge?
yes,
Do you know which judge signed it?
it was, Judge Cruz.
Okay, and would you recall this order if you saw it here today?
Yes,
Your Honor, may I approach the witness?
Yeah, you can have that marked.
I do not have an exhibit sticker, Your Honor.
We'll give you one. We're gonna mark those. We'll have it marked People's one, okay?
Would you like it marked before getting?
Yes. And then if it is admitted or either way, you're going to be responsible for holding on to it, okay? So we'll have that marked People's one, and then once she hands it back, you can approach the witness.
Thank you. I did have a huge list of exhibit stickers, had a bunch of them and I cleaned my bag and no longer have.
No worries.
To get some.
I think they cost about a penny a piece. I don't know.
Thank you, Your Honor. And now, Miss Sarah, do you recognize, I'm handing you people's proposed exhibit number 1. Do you recognize what I've just handed you?
yes, I did.
And could you please tell me what it is?
This is our custody order, it's our up-to-date order for parenting time and for parenting.
Okay, and do you recall when this order was in place?
Yes, it was February 2022.
And does it appear to be accurate depiction of the order?
Yes,
And does it appear to be manipulated or altered in any way?
no, it doesn't.
Okay, Your Honor, I'm just kind of moving to this.
Any objection, Mr. Anderson?
No objection.
People's one is admitted. You can hand that to my recorder unless you're gonna ask questions about that.
Thank you, Your Honor.
You
Thank
want her to have that document to,
potentially for refreshing.
okay, go ahead, hand it back if you would, Sadie. You can proceed.
Now, Ms. Sarah, you stated that this order was in place on which date?
It was February 18th, 2022.
Okay, and what did that order state with regards to custody between you and Mr. Timothy and Noah?
It said our parenting time for Timothy would be every Saturday at 10 a.m. to Sunday at 8 p.m. with telephone and or virtual parenting time every Monday, Wednesday, and Friday at 6. And I don't know where it says it, but it also says other parenting time as parents mutually agree. It says that in here somewhere.
Okay, and at any point did you deviate from the times that were allotted by this order?
Yes, on December 20th of 2024, we discussed.
Wait a minute, is this 24 or 25?
It goes into 25, but it was 24 to start.
Okay,
Right? Am I in or am I wrong? I'm sorry, is it? Yes, it was December 20. Yes, December 2024, and then it changed to 2020. Sorry about that. I was.
Of course.
So it was the end of December, yes.
Okay, and was it just to confirm last Christmas or this past Christmas that just happened?
Christmas before it was passed.
Okay, and now, what occurred?
On the 20th, we both discussed, Timothy and I, that he was going to take them on 20th and return them on Sunday, the 22nd, and then pick them up again on the 22nd and return them on Christmas Eve evening, so I could have them for Christmas morning.
And did he return him on Christmas Eve evening?
No, we didn't.
Okay, and did you try to contact him?
Yes, I did.
And how was it you tried to contact him?
I messaged our son and Noah, and Timothy responded saying, "This is Tim, and you're not getting him back." I've notified authorities and other people, and so we can go to court about it.
Okay, and when was the last time that, when were you able to get your son back?
February 18th.
Okay, and did you file a report about this?
Yes,
Do you recall when you filed the report?
I filed one on the evening of Christmas Eve.
Okay,
Late at night, I wasn't coming back, I went to the police station.
okay. And do you recall, you stated that you made a police report, and do you recall if this order, this one that you're holding, the order from 2022, was that in place on January 14th of 2025?
Yes,
And when is it that you were able to get your son back?
January 18th, 2025.
Okay. One moment, Your Honor.
I think you misspoke, though. You're talking about Christmas Eve of 24, right?
Yes, Your Honor.
And she's talking about January the 14th or 18th of 25 that you got the child back.
January 18th of 25.
So about 50 weeks ago, right?
Yes.
Okay, go ahead.
Nothing further, Your Honor.
Can you, do you recognize Mr. Shelton here?
Yes, I
Can you identify him?
Yes.
Point him out, tell him what he's, telling us what he's wearing?
I'm just wearing a checkered shirt, and black shoes, and
All right, what record should reflect that witnesses identified the defendant?
Thank you.
Cross-examine.
Ma'am, you do acknowledge that, there's an agreement between you and him that the son was to be returned on the 24th, your house.
Of what month?
The 20,
December of 24?
24.
I'm sorry, can you repeat that?
Okay.
You acknowledge there was an agreement between you and Mr. Shelton that the child, your son, was going to be returned on December 24th of 24.
Yes, sir.
You're also aware that your son had been running away from your home a lot around this time because of allegations of abuse by the man that was in the house with you and yourself.
That happened, he was starting to run away when I got him back after the 18th of January in 2025. The first 2 days that he was home, we ran like 4 times, but nothing before that. We had a great relationship on December 24th of
Yeah.
2024.
You remember being interviewed by the police and talking to the police regarding your son running away from your house?
Yes, I do. They told me to just go inside.
Do you recall your son saying that he had been physically abused?
Hang on a second. Can you repeat your last question?
Oh, I'm sorry. The question was whether or not that her son had said that he had been physically abused by herself and her partner, Mr. Parker.
I said,
And Your
yes,
Honor, I objected to your say so of the sunset here.
Any response?
I'll move on here.
Thank you. Sustained. No. Any response to that is strict.
Would it be fair to say then, according to you, that he started running away from home in January once he was ordered to come back to your house, correct?
And Your Honor, I'd object to speculations to why he was running away.
Well, if he knows, he can answer.
How would you know
How
why?
does he know except through the knowledge of others? I'll sustain. And which would be imparted to her by hearsay statements.
Did you ever have a conversation regarding your son as to why he left the house or would not come back to the house on Christmas Eve, December 2024.
Conversation with whom? What do you mean?
Mr. Shelton, Timothy Shelton.
He text messaged me from her son's phone saying he wasn't returning them.
Did he say why?
Yes, he said he had concerns and he had notified authorities in Brownstown and Adrian where they were staying, and that was false.
No, I'm just asking whether or not he told you that.
He did, but it was just intimidation because he really did it.
Well, ma'am, I didn't ask you that. Let me ask you this then. He also told you then that,
I also object to any of the statements that the defendant made, that are not part of the policy.
Nice and loud for me.
It's not statements against his interest, Your Honor, so it's hearsay.
True. Right? Sustained.
you got me, Judge.
Yep.
All right,
These young lawyers, you gotta watch out for them.
so, notwithstanding that, is he still staying with you today?
Yes, sir.
And he's 14 years of age?
Yes, sir.
And have you been back to court at all? I'll start that question. Have you completed the parenting time that you were supposed to cooperate with Mr. Shelton in terms of visitation of your son?
Well, Your Honor, I'd object to references to this specific case.
I only say that because Your Honor, at this, when this was going on, my client was awarded parenting time, where he was able to visit his son, supervised, of course. And it's our position that she stopped that.
But this is after the fact, right?
Well,
It's after the incident of December 24 of 24, right?
yes, however, there's still a certain court order in effect.
So what is your position? You're gonna show that she violated the order that justifies him violating the order in December of 24?
Well, I would state that it shows that she violated the order. It's an open order as far as I know, it's still in effect.
I'm gonna sustain the objection. I'm sorry.
Ma'am, your son is not receiving any counseling regarding this incident, is he?
Or no.
Thank you. Nothing further.
Redirect? Call your next witness. You can step down, ma'am. All right, people move to bind over.
Yes, Your
You agree it's a fact question, Mr. Anderson?
I do, Your Honor.
Case is bound over for further proceedings to the Wayne County Circuit Court. 50,000 PR bond. You don't have any objection to continuation of that, do you, counsel?
No objection.
I'm gonna go ahead and continue the bond. 50,000 PR, same terms and conditions. Your AOI date, you being out of custody will be on January the 20th. And that'll be at 9 o'clock in the morning in the Criminal Justice Center. And a bond will remain at 50,000 PR. Same bond conditions. No contact with Sarah Passalacqua or Noah Shelton, except to effectuate visitation in accordance with the judge's Third Circuit order through third-party contact supervisor. And the visit to be scheduled through GrowthWorks. No firearms or dangerous weapons. You cannot leave the state, cannot violate a law. You must appear in court as directed. I wish you well, sir. Good luck to you. Thank you.
Thank you, Your Honor.
Thank you both. And Happy New Year. Nice to have you here, Mr. Anderson. Sorry you had to wait so long.
Today's docket delivered two powerful courtroom lessons. In the first case, a judge carefully dissected medical evidence, witness credibility, and statutory definitions, ultimately dismissing the strangulation charge while allowing other assault counts to head toward trial. In the second, a bitter custody conflict escalated into felony accusations, with the court binding the defendant over to circuit court and imposing strict bond conditions designed to protect the child while preserving due process rights. These hearings show how much rides on details, medical findings, recorded testimony, court orders, and even how clearly a witness answers questions on the stand. One subtle factual gap can collapse a charge, while a violated custody order can launch a case into much higher stakes. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.